Welcome to today's presentation, which is on disclaimers. As always, this presentation is intended primarily for insolvency professionals, people who work in insolvency as their day-to-day job. These are the topics I'm going to be covering today. I'll be talking about what disclaimer is, looking at which office holders have the right to disclaim. Then under the heading of why disclaim, I'll be looking at the situations in which you might be able to disclaim and some of the law around disclaimer. Then I'll move on to the disclaimer procedure itself and how you go about disclaiming a property when it's appropriate to do so. And finally, I want to talk about some practical examples and give some real life situations when you might find it appropriate to be disclaiming a property. So let's start by looking at what is disclaimer. And disclaimer is entirely a statutory right under the Insolvency Act, and it allows you as an office holder to get rid of unprofitable contracts or other types of onerous property, so they're no longer part of the assets that you have to deal with in your capacity as office holder. It ends the interest that the estate has in that property, that contract. But it doesn't destroy the property, it just brings your interest in it to an end. It does not affect the right that other people have got in that property. And that does mean that third parties are very often affected by disclaimer. In fact, that's usually the whole point of the disclaimer, is because other parties have got an interest and their interests are actually acting to the detriment of what you need to do in the estate itself. So one of the ways that those other parties can be protected is they have got the right to apply for a vesting order, which would then make them the owner of the property instead of the bankrupt or the insolvent company. I'm not going to say any more about that because it's very unlikely to affect you as liquidator or trustee in bankruptcy if somebody does apply for a vesting order. So the property was owned by the insolvent company or the bankrupt before your appointment. In the case of a bankruptcy, it vested in you on your appointment. You then disclaim it, and it's no longer owned by you as trustee in bankruptcy, no longer owned by the insolvent company. So who does it belong to? It does not revert back to the bankrupt. Although disclaimer divests you as trustee in bankruptcy of the property, it doesn't return it to the bankrupt. And there are a couple of routes. In most cases, the property will become bona vacantia and will vest in the Crown. If it's freehold property that is owned solely by the bankrupt, it passes by escheat directly to the Crown. In either case, it doesn't really matter. It ends up with the Crown or Duchy of Cornwall, Duchy of Lancaster will be the owner of the property once it has been disclaimed. I'm not going to say any more about escheat or bona vacantia. Again, it doesn't normally affect you. Let's now look at which offices give you the right to disclaim. And there's only two of them. You only have the right to disclaim if you are a trustee in bankruptcy or if you are a liquidator. Other office holders do not have the right to disclaim. Generally speaking, disclaimer works pretty much the same way, whether it's a liquidation or a bankruptcy. There is one important difference for bankruptcies, though, and that is that as trustee in bankruptcy, the property will have vested in you personally on your appointment, and that means that you can become personally liable for various obligations arising out of ownership of that property. Disclaimer, although it divests the property from you from the date of the disclaimer, in the case of a bankruptcy only, it also releases you from personal liability arising from that property, and that release is backdated to the date of your appointment. So effectively, if you find yourself as a trustee in bankruptcy having an argument with a landlord and you disclaim the lease as a way of getting rid of it and bringing the argument to an end, if the landlord comes back to you and says, that's fine, but what about my rent from the date when you took office until the date of disclaimer, You say, well, okay, I'm actually released from that. I don't have to pay it. That's not my problem. In the case of liquidations, the power to disclaim is the same whether it's a compulsory liquidation, an MVL, or a CVL. I sometimes think that the three types of liquidation should be regarded as totally separate procedures, but for purposes of disclaimer, the rights and procedures for disclaimer are pretty much exactly the same. One thing that is important about disclaimer, and is particularly relevant in the case of MVLs, is that disclaimer is not cost-free. That when you disclaim property, you are very likely to be giving the parties affected by the disclaimer a right to claim in damages. And this is particularly relevant in the case of something like a lease. If you have a lease with, let's say it's got 7 years still to run on it, and before the MVL started, the company had tried to find an assignee for it, but couldn't pass the lease on to anybody else. The landlord isn't interested in talking about any sort of surrender of the lease. You've then got the option of disclaiming it. That will bring the lease to an end, but it will give the landlord a claim for damages for breach of contract to compensate the landlord for the loss that they have suffered from no longer having the lease. Now, in the case of a 7-year lease, it may actually be a lot cheaper to disclaim it and pay the damages than it would be to carry on paying out for the lease to the end of the term, or to pay for a surrender of it. But that will depend upon the circumstances. But you have to remember that disclaimer is not cost-free, and you may well be triggering, in many cases, a claim for damages for breach of contract by making the disclaimer. In bankruptcies and insolvent liquidations, that's less likely to be important because, of course, that claim for damages will only be relevant if you're in the position of being able to pay a dividend to unsecured creditors generally, and that claim may dilute the claims of other unsecured creditors, but it's not going to affect any party quite as fundamentally as the shareholders of an MVL might be affected by the cost of having to pay damages for a disclaimer. Administrators, of course, do not have a statutory power to disclaim, but administrators do have the power to convert the administration into a liquidation, either a compulsory liquidation or a voluntary liquidation, depending upon the circumstances. And if a disclaimer is very relevant to the restructuring that you're undertaking through the administration, you might want an early conversion to a liquidation so that you can get on and disclaim. Supervisors of a voluntary arrangement do not have the power to disclaim, but we have seen quite a number of carefully planned restructuring voluntary arrangements, particularly retail chains. And in a restructuring of that sort, to take a very simple example, you'll often have the leases will be separated into two lists, the list of good shops and the list of bad shops, and the CVA will often provide for the company to continue trading from the good shops only, but for the leases of the bad shops to be treated as having been terminated. And in a case like that, the way that those leases are terminated is usually modelled very closely on the way that a disclaimer would work if the company were to go into liquidation, with the landlords of the bad shops being given the same sort of rights to claim for damages for losing their rental income that they would have if the lease were to be disclaimed by a liquidator. So although disclaimer can't be used in a voluntary arrangement, or indeed any sort of procedure other than liquidations or bankruptcy, nevertheless, knowing about how disclaimer works and how to use it can itself be a really useful restructuring tool that can be effectively written into as a contractual term of a voluntary arrangement, for example. So that's looking at who can disclaim. Now let's look at the detailed rules about why you can disclaim, the situations in which you can disclaim. And essentially, there are 5 of these. You have to be able to tick at least one of these boxes to have the right to disclaim. So if the contract is unprofitable, if it's costing you more money than it's worth, if you can't sell the property, or if it's proving to be too difficult to sell the property, if the property or contract in question is costing you money, or if there are other obligations on it that mean that it's not worth hanging on to it and trying to sell it. In any of those situations, you've got the right to disclaim. If you step outside the bounds of that and you disclaim in a situation where you should not do so because you haven't got one of those conditions applying to it, then there are a number of interested parties who could apply to the court to ask the court to review and overrule your decision. And that's the usual provisions in liquidations, section 112 in voluntary liquidations, section 1685 in all liquidations that give the court a power to review your decisions, and in bankruptcies, similar power in section 3031. And the 2 situations when the court might interfere and overrule the decision of an insolvency practitioner as liquidator or trustee in bankruptcy is if the decision is perverse, which it would be if you were going beyond your statutory powers, or if it were in bad faith, if you had an unprofessional motive or justification for wanting to make that decision. And in the case of a compulsory liquidation or a bankruptcy, the category of interested parties who can make a challenge of that sort is incredibly broad. In a voluntary liquidation, it's limited to only a creditor or a contributory, and the contributory is unlikely to be able to make a claim unless it was looking like it was going to turn into a solvent liquidation or was already a solvent liquidation. In a bankruptcy, the bankrupt, of course, is among the group of people who have the right to object. And one of the reasons why a bankrupt might object to disclaimer by a trustee is if you disclaim the family home. Now, as I've said, disclaimer doesn't revest the property in the bankrupt. It passes the ownership of that property to the Crown. So if you disclaim the bankrupt's former interest in the family home, you're passing that to the Crown rather than letting it drop back into the bankrupt's possession. And there are public interests in not chucking people out on the street unnecessarily, not ending their right of occupation to their own home without good reason. And you do have an alternative as a trustee in bankruptcy when you're dealing with the family home. You do have the option of revesting it in the bankrupt. And that's in Rule 10.170 of the insolvency rules. And it's very, very simple. You just have to give written notice to the bankrupt saying either that you think that continuing to hold the family home is not going to benefit the creditors, or just thinking it'll be more efficient dealing with the estate if you revest the property in the bankrupt. And once you've given that notice to the bankrupt, then the interest in the family home revests in them after 1 month. If you're not familiar with the technical workings of this, this is basically written into the arrangements for the 3-year use it or lose it rule. And what you're doing by giving this notice is you are accelerating the 3-year revesting period so that the revesting takes place not after 3 years, but 1 month after you've given this notice to the bankrupt. So if you're dealing with the family home, it is very often better to revest rather than to disclaim the interest you've got in it. I'm reluctant to stand up here as I do once a month and encourage you to go and get legal advice on stuff, as I'm not sure that's always terribly helpful. But I would suggest in preparing a disclaimer notice, particularly if the property is one that might have some value to somebody, do perhaps ask a lawyer to review the wording of the disclaimer notice to make sure that the property is accurately described in it, to make sure that it is effective as a disclaimer notice. And you do have the ability to disclaim an interest in the property, even if you don't think that the bankrupt has an interest in it. So if you've got a bankrupt who's banging on about some asset or other, and what are you going to be doing about it, and you actually think this asset either doesn't exist or the bankrupt never had an interest in it anyway, and I just do not want to be involved in this any longer, you can disclaim such right, title and interest, if any, of the bankrupt in that property, and you'll then be saying, look, I don't think you've actually got any interest in this, I don't think it's anything to do with me, but in case it was, I have now disclaimed it. And that can be a way of getting rid of those sorts of arguments as well. The other area where you could get a challenge is coming from exactly the opposite direction, and this would normally be a landlord giving you 28 days notice to decide whether you are going to disclaim or not. It doesn't have to be a landlord. Anybody with an interest in a particular property that's in the estate can give you a notice of this sort. And again, there are no statutory forms. All they've got to do is ask you in writing if you are going to disclaim the property or not. And you have to deal with that notice within 28 days. If you don't do so, then after 28 days, you will lose the right to disclaim. So if you get a notice of that sort, then yes, you really do have to make a decision fairly swiftly on whether you're going to disclaim or not. You need to move that up the list of priorities. There was a fashion a little while ago, I don't know whether it's still continuing or not, for local authorities to give a notice of this sort about property, and they said that they had an interest because they wanted to ensure that they were collecting the rates from that property, and they thought it was in their interest to force a decision on whether you were going to disclaim the property or not. The Insolvency Service think, and I think they're absolutely right about this, that local authorities as a rating authority do not have an interest in property that entitles them to give a notice of this sort, asking you to decide whether to disclaim or not. And if you do get a notice like that, you shouldn't just ignore it, but you should just politely say to them, I don't think you've got the right to try and force this decision upon me, and therefore I will be making my decision to disclaim at a time that suits me rather than necessarily within the next 28 days. And just a reminder here about the timing of disclaimer. The disclaimer notice is normally effective in transferring the property out of the estate on the date on which you authenticate it. There are a couple of circumstances when it's a different date from that, but that's the general rule. But as I've already said, in addition to that, in a bankruptcy, you are released from personal liability for that property from the start of your appointment. So although the property is only transferred out of the bankrupt estate when you authenticate the notice of disclaimer, nevertheless, for the purpose of releasing you from personal liability for that property, that is then treated as effective right from the start of your appointment. And that can be quite useful. So that's the sort of rules around disclaimer, when to use it and why you might want to use it. Let's look at the procedure itself and how you go about disclaiming it. It's not accurate to say fill in the form anymore because, of course, under the insolvency rules, there are now no forms. But if you look at Rule 19.2, you will see the list there of what you have to put in the disclaimer document to make an effective disclaimer. And to make it effective, you have to authenticate it and date it. And then once that's been done, you've got a short period of time to deliver it to anybody with an interest in the property and various other parties. If you miss somebody out from this list, it's not the end of the world, because you can give notice to people later on. But best practice is to give notice at the earliest opportunity to everybody who needs to have notice of it. First group of people who need to be given notice of the disclaimer is anybody with an interest in the property, which would be landlords, tenants, subtenants, anybody in occupation, mortgage lenders. There may be others. And again, sorry to do this again, but you might want to get a lawyer just to review the disclaimer notice and give you some guidance as to whether you have listed everybody who needs to have notice of the disclaimer notice. If it's a lease, or in fact any sort of property where there's somebody with a continuing liability for that property, you need to give them notice as well. With a lease, that's going to be typically any guarantors of the lease, and it may also include former tenants of the lease as well. If it's an unprofitable contract that you're disclaiming, then the other parties to the contract need to receive the disclaimer notice, as do any other parties with an interest in that contract. The list goes on, and this is a lovely one. Anybody else that you think should be given notice, you've got the ability to give them notice as well. And that's really useful, because it's saying, if in doubt, give them notice of the disclaimer, because you're always entitled to do so under this particular provision. If it's a liquidation, Companies House need to have the disclaimer notice. If it's a bankruptcy, then either the bankruptcy court or the bankruptcy file gets a copy of the notice. And if it's registered land, the land registry also gets a copy of the notice as well. So that's how to disclaim. It's a very, very straightforward, uncomplicated process. Finally, now I'm going to talk about when to disclaim in terms of looking at some practical situations when it can be useful to disclaim, when it can make sense to do so. I've already talked about the situation where you might want to convert a contract or a lease into a damages claim to get rid of a long-term liability, something that's stretching forward into the future, and convert it into a damages claim. And that can be particularly useful in MVLs, where you need to quantify a claim, pay it in full, and to get rid of a continuing liability on the company. But there might be other cases when it can just be very, very useful to convert a complicated claim into a much simpler one for damages. It's not necessarily going to be that straightforward, because there will be arguments about what the nature of the claim should be, what the quantum of it will be, and you may need all sorts of expert evidence to assess that. You may end up litigating that as well in some cases, but generally speaking, it is a way of simplifying claims in both solvent and insolvent procedures. As examples of that would be typically leasehold premises. Second situation when you might want to disclaim a property is to avoid capital gains tax liability. And of course, CGT is payable as an expense of the liquidation or the bankruptcy, as the case may be. And it's an expense that you will have to pay if the CGT is incurred. And you might find a situation where perhaps there are properties which are in the hands of the mortgage lender or their receivers, and those are being sold, and the sale of those may be triggering CGT bills, but none of the proceeds of sale might be coming to you because there may be no equity in the property. So you could find yourself in a situation where you're having to pay CGT on realizations that you've got no control over and you're getting no benefit from. And the way to deal with that is then to disclaim those properties so that they are then outside the estate, and the realization of them will not make you liable for paying the CGT as an expense of those. Now, as I understand it, the liability for CGT is triggered on exchange of contracts rather than completion of the sale. So this is probably something to assess early on after your appointment and to keep reviewing it. and to disclaim properties of this sort sooner rather than later, because if you disclaim after contracts have been exchanged, that may be too late to avoid the liability for the CGT. Sometimes you just disclaim a property just because it's more trouble than it's worth. It's complicated to deal with, it can't be sold easily, there are arguments about it, whatever the case may be, you just want to be rid of it, and it's actually going to be cheaper getting rid of it now and realising nothing for it than continuing to spend time and possibly money on it when you don't know what it could be sold for in the future. And a couple of examples I've been involved in recently have been reversions of small blocks of flats where, because there's a procedure that has to be followed in terms of giving notice to the leaseholders, it's expensive, it's time consuming, and in a couple of cases I've seen trustee in bankruptcy has quite reasonably concluded that it's just not worth carrying on with the potential sale of those properties because it would realise so little, take so long and cost so much to do it. Environmental liabilities might be another situation where you would be thinking about disclaiming the property. If you're looking at contaminated land, then to get rid of the contamination, you should disclaim the land itself to get rid of both the land and the contamination on it. It would be a mistake to try and disclaim only the contamination without disclaiming the land as well. And again, I'm afraid for the third time today, this is where I'm going to be saying this is an area where you really would need to take professional advice on the particular circumstances of the situation that you're looking at. It's quite legitimate and possible to disclaim a pile of waste that is on somebody else's land. And again, I had a situation like this a few years ago where the company pre-appointment had vacated leasehold premises and it had left several drums of liquid on the landlord's premises. The drums were starting to leak. Nobody quite knew what was inside them. And one option that we looked at for dealing with those was to disclaim that as onerous property, which would have just left the problem entirely with the landlord to deal with. Remember, of course, you may well find that in a situation like that, the landlord will have a claim against the company for breach of covenant under the terms of the lease. So this may not be cost-free. There may be a claim coming in for something like that. If it's an MVL, it may be less expensive for you as liquidator to pick up the cost of dealing with it than it would be to leave it with the landlord to deal with, and for the landlord then to pass their costs onto you for it. And one thing you'd have to watch out for is not disclaiming that pile of noxious materials in the corner of the empty factory if the company still has a lease of the factory, because then by disclaiming that pile of noxious waste, you're passing it to somebody else, you're vesting it in the Crown, in effect, and that then means that you would be storing somebody else's waste on the company's premises, and you would normally need a waste license to do that, and to do so without having a waste license could result in all sorts of statutory complications for you, so that would not be a sensible thing to do. Talking about waste management licenses, you probably know that these are property and can therefore be disclaimed. They are being replaced by pollution prevention and control permits. There is a difference of opinion between the Insolvency Service and the Environment Agency about these. The Insolvency Service thinks that these can be disclaimed in much the same way that a waste management license can be disclaimed. The Environment Agency disagree. So if you are looking at disclaiming a pollution prevention and control permit, just be aware that there is the possibility that you may end up in a test case if you do that. If you are disclaiming either a waste management license or a pollution prevention and control permit, you have to give notice to both the Environment Agency and also the Environmental Health Department of the relevant local authority. So those are the 5 topics I wanted to cover. We now have the summary slide, which is just to remind you, disclaimer is for liquidators and trustees in bankruptcy only, but nevertheless, disclaimer can be regarded as a useful restructuring tool and a good model for writing a CVA proposal that sort of disclaims property in it in appropriate circumstances. It may be better to revest the family home rather than to disclaim it if that's the situation you're looking at. And remember that disclaimer will create a claim in damages for breach of contract in many cases, so it's not cost-free, and that can be particularly important in something like an MVL, a solvent liquidation, where you would need to weigh up the cost of dealing with the damages claim as against the cost of the other options for dealing with the property. And disclaimer can be a useful way of dropping properties out of the estate before they're sold by third parties like a receiver or a mortgagee, and to avoid triggering a capital gains tax liability as an expense of the bankruptcy or the liquidation, as the case may be. So those are all of the points I wanted to cover. I don't think there are any questions, but do email me later if there's anything that you're mulling over in your mind and you'd like clarification on. Always happy to deal with that. And as promised, here are some dates for your diary. Next Thursday, we've got the R3 Southern and Thames Valley Forum, which is in Bournemouth, just down the road from me here. So I will certainly be going to that. They'll probably only be selling places for that for a few more days at best, I should think. We've got SESCA insolvency seminars at Denbies in May and October this year. We've got the SESCA insolvency conference in Reading in September, and we've got the R3 SPG forum in Stratford upon Avon in November this year. And most importantly of all, Friday the 13th of June is Fretton's 4th annual insolvency conference, which is being held at the Bewley Inn in the middle of the New Forest, and I hope to see as many of you as possible at that. So with all of that, thank you very much for joining me this morning, and see you again next month, if not before then. Thank you. Goodbye.